respect of this writ petition, my lord. Passed therein, the matter on the file of this court as on date were kept pending only for the purpose of verifying whether the direction of this court in the state of West Bengal versus Boishaki Bhattacharya, Chatterjee and others were implemented scrupulously. As a learned judge of the Calcutta High Court has now taken up that issue also, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertake the exercise instead of this court. So, Supreme Court purpose is very specific, because Supreme Court pending this matter only for the reason of that whether the Boishaki Bhattacharya's order was scrupulously followed or not. For that reason, because my lord's taken up this writ petition, the Supreme Court says, as a court of first instance, the High Court, let's take up the matter. Now, the very next paragraph. It would be open to the all the petitioners stroke applicants, because before the apex court they informed, directly they went to the Supreme Court against that order, and that various applicants says we have also matter connected with this, because various prayers in this writ petition. I will place the prayers later on, my lord. Before that, my lord, I place this order. The High Court shall, however, ensure that this is the most important paragraph, my lord. The High Court shall, however, ensure that none of the tented candidates are permitted to slip through in the fresh selection, be it on that or any pretext. So, my lord, the Supreme Court purpose to return back this writ petition is that none of the tented candidates in any form, on any pretext, slip through the net. The High Court shall also ensure that means additional duty. High Court shall also ensure that the list of tented candidate is placed in the public domain with full details, so as to ensure that this does not happen. So, because of that, my lord, this is what my humble understanding is that, my lord, this is a continuation of first SLST 2016 selection process. The Article 12 authority, they made mistake, they did corruption, they did illegalities. It's a combination of three. For that reason, the first SLST 2016 was cancelled and set aside with a specific direction: return back to money whosoever tented candidate. Tented candidate will not sit in the next recruitment process. But what is the conduct of the SSC and state? I will show one after another, my lord. What they did after passing the judgment, my lord, Boishaki Bhattacharya, first time they tried to accommodate all the tented candidates. In pursuance of court order, they are unable to do so in the first round after Boishaki Bhattacharya. Thereafter,
how did they try to accommodate?
Because they try to accommodate tented candidate, they give opportunity to participate in the tented candidate.
Who were expiry?
That happened in July.
Not expiry panel, my lord. It's the first round. My lord will remember.
That July.
Dolui matter. They try to they take online application from the tented candidate also. Kolkata High Court single bench, Honorable Justice Shogata Bhattacharya passed that order. No tented candidate will allow. Thereafter, the state and SSC both went to the division bench. Division bench order. And that order, in pursuance of that order, there is specific mention: no tented candidate will be allowed. Thereafter, they again allowed the tented candidate. What they says, my lord will remember, in that matter, my lord, they says no. We just only allowed that whosoever physically handicapped tented candidate, they can pursue. My lord will remember. Thereafter, in pursuance of my lord order, they are unable to accommodate their position. They went to the Supreme Court. Supreme Court says no. There is no such tented candidate, whether in the form of general candidate or tented. So, in 2 rounds, the School Service Commission, first, they made mistake in that respect of 2016. Second round, they want to accommodate tented candidate. Third round, they want to accommodate PH tented candidate. Now, my lord, 4th round, I will show, my lord, one after another by dint of the Supreme Court order and my lord's order, comparing two, my lord. They again, my lord, give space to the tented candidate. I will show, my lord, from the Supreme Court judgment itself. Learned counsel in some of the cases seek relief in the terms of certain paragraph of the decision in Boishaki Bhattacharya Supra. They are at liberty to raise such hermeneutic exercise before the High Court. The special leave petition application are disposed of the aforesaid terms. Now, my lord, very next paragraph is very important. All, my lord, Supreme Court, my lord, consciously did it, and I will explain why this consciously did it. The High Court shall examine the matter uninfluenced, most important word, uninfluenced by any of the observation on merit made by this court in the orders passed after the decision in Boishaki Bhattacharya Chatterjee Supra. Supreme Court gave all the power to the court of first instance, even which was the order from passed. It might be any type of order that is uninfluenced. So that order is not even binding upon the single bench. Supreme Court unequivocally says so. Now, my lord, the High Court shall also be mindful of the fact that the untainted candidates, that not untainted employee or untainted teacher, untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected by application of the new rules. That is the West Bengal School Service Commission selection for appointment to the post of assistant teacher for upper primary level of classes, except work education and physical education, classes 9, 10, and 11, 12 rule 2025. So that is the Supreme Court. The Supreme Court says, as per my humble understanding, two things. One is that no tainted candidate in any form or any pretext is allowed in the present selection process, number one, and court of first instance will ensure it. That is a bounded duty upon a court of first instance by the Supreme Court, number one. Number two, any order passed in the meanwhile, after 3rd April order, uninfluenced by that order. That is most important. Now, my lord, I will show, my lord, the Supreme Court judgment, that is Boishaki Bhattacharya judgment. Boishaki Bhattacharya copy them. What was there?
We are already nearing 4:30.
Malad, then kindly keep this matter, my lord, tomorrow as a top matter. Malad, why? I will explain, my lord. Because of that, my lord, this is not about, I follow what fallen from my lords. My lords have that power. My lords can even alter even after selection. But with my humble understanding is that, my lord, the constitution, my lord, give this duty to any judicial authority or executive authority, act in aid of the Supreme Court, that is Article 144. And not only that, my lord, Supreme Court specifically in this matter. Why Supreme Court bound give this duty? Because of that, in pursuance of Supreme Court judgment, that selection process was set aside. Thereafter, my lord, in pursuance of Supreme Court order, this selection process is going on. And not only that, they advertise it in that form. So if in pursuance of Supreme Court order, this selection process is going on, and that instant selection process, the tainted candidate again take place, my lord. I will show even they place 4 list. I can show from the judgment itself. They consciously not place another list. What type of list? Kindly take just one paragraph. My lord, para 37 of my apex court judgment. Para 37. They consciously not did it. And that is, my lord, what my learned friend says, that is in Setabuddin matter, in the pretext of something else, my lord. That was my matter. I know on which pretext, my lord, that order was passed. Kindly take, my lord, para 37, a chart, a tabular chart. My lord, assistant teacher for classes 9, 10, WBSSC recommended 11,425. Now, my lord, number of appointment letter issued by the board, excess 1071. Board is party in the instant writ petition, my lord. Whether board places that list, who are that excess candidate? No. They also slip through. They also sat in this tented as a tented candidate. Who are that? These two authorities, my lord will remember on the last occasion, I suggest one thing because I believe, my lord, everybody will accept that. What are our endeavor? Right of employment is not given in our constitution, but equal opportunity in public employment, that's my fundamental right. I believe everyone's endeavor is that let's make this selection process a fresh but in a fair manner.
Well, only one small interjection. If my learned friend makes submissions which touches upon who are tainted, meaning thereby whether expiry panel those persons are tempted or not, then my lord, I would be only requesting that lordship take it finally as lordship is doing it. If his prayer, interim prayer is anything other than that, I have no difficulty.
Yes, I
But
have.
but
I have
ultimately, your lordship
I
has
not
to
clear.
decide that the tainted means exactly what. Does it include all who have been appointed after expiry panel,
Not
or the Honorable Supreme Court use this term exactly for some specifically tainted persons in the specific paragraphs in the judgment of the Honorable Supreme Court? All I'm saying that Lordship will decide it, but what my learned friend wants it, ultimately, my lord, whatever he wants, it will have a
Touch the
bearing.
panel.
It will have a bearing on. He wants to have the panel. That lordship is passing the orders in other matters also. That should be produced before your lordship. No difficulty for that.
In my interpretation, the expiry panel is not the only point. In my interpretation, my lord.
So today another group comes in. That means excess appointment letters issued by the board.
Yes.
This list
Only
is
that,
also
my
required.
specific prayer regarding OMR sheet publication of two sets of selection process. One is 2016 selection. I have specific prayer as well as
2016,
interim.
the Supreme Court already granted order.
No, not yet, madam. Because of that, Supreme Court take up that SLP, that is which evolved from that whether the High Court will take up that contempt or Supreme Court. That SLP is fixed on the month of January. So that yet not madam.
Right.
So, madam, my in this interregnum period, I have threefold prayer as an interim prayer. Why? And I believe that is innocuous one, and that will not touch anyone. One is that, madam, already division bench passed that order 363 subpara 3.
No, that has been modified, my lord. Sorry.
Modified, my lord, we have.
No.
Just wait, yes.
I just place my case, Malad, that is not 2025. I believe, Malad, if